So I think it would have been interesting to start this session discussing exceptions for libraries, because that's definitely one of our main objectives, is first to create exceptions for libraries. But then I'm the first intervening, and my intervention is on another issue that we encounter when thinking about legitimate, fair uses, reasonable uses of copyrighted content in the library sector, which is the issue of licensing. Because we have transitioned from a sales-based model in printed publications to a license-based model in digital publications, what happens is that even if you have a fit-for-purpose framework that allows libraries to make certain uses of copyrighted works, they still need to rely on licenses to have a first access to the material. And that gives to publishers a lot of power in determining what libraries can and not do with the licensed materials, even if you have exceptions that allow them to make certain uses. So we know this, and we also know that these licenses tend to be subject to confidentiality agreements, which means that we don't know what are the terms of these licenses. For these reasons, we decided, so Communia is a non-profit based in Brussels. We have been involved in copyright reform for many years. We have been coming to the SCCR for many years. And we decided in February this year, we invited licensing managers, so people that are from the library sector, public library and academic library sector in Europe. We invited them to come to Brussels, and we held a Chatham House Rule meeting. We also invited the European Commission to attend this meeting and observe this meeting. And this environment where people could not attribute each other was the right environment for licensing managers to come and talk about the issues that they are facing with the licenses. So the unfair licensing practices, the unfair terms that they are being subject to. So I will be mentioning some of those practices, and I will start with a very hot topic right now, which is the topic of AI, but also text and data mining for scientific research. And what we noticed when discussing with the libraries, and maybe I should also tell you that in addition to inviting librarians to come and talk to us in private, in front of the Commission, we also invited them to share with us in confidence clauses that they considered unfair, clauses that are part of those licensing agreements or licensing offers. And what we realized is that, and maybe here for those that are not European, I should give you a bit of legal context of Europe. In Europe, 6 years ago, we passed a new directive that guarantees that researchers in Europe can make text and data mining uses of copyrighted materials for scientific research. So we have a mandatory exception for these research uses. And this mandatory exception is protected against contractual overrides. And what does that mean? It means that if a license says that you cannot make those uses, you don't need to follow the license because the law, the European law, protects you. This means if you are a researcher based in the EU. And then we were very surprised that publishers were actually concerned about prohibiting these uses in Europe when we have a law that allows these uses and prohibits contractual overrides. But that was indeed the case. So we noticed, and they told us that since 2023, so place it at the same time where generative AI is raising, suddenly all the contracts are saying library users cannot conduct text and data mining on ebooks and e-journals that are available in the libraries. They cannot conduct any related AI uses with those materials. And surprisingly, what was interesting to see was that while they were actually concerned about putting those prohibitions in those contracts, although the law would not allow for those prohibitions, because they could circumvent the EU policy, the EU law, and our contractual overrides prohibition by selecting a law that's outside of Europe. So we know that choice of law is typically a clause that the parties need to negotiate and takes time to negotiate. Everyone wants to choose their own law. But in this case, by choosing a law that's not the national law where the library is located, meaning that's not the EU law, which would protect these users against contractual overrides, they are able to circumvent basically the EU law and the prohibition of contractual overrides. And that's enough. So imagine all of the work that we have done throughout the years to have exceptions in place, exceptions that are protected against contractual overrides, is simply circumvented by a choice of law clause. I'm going to give you an example of what prohibition of AI uses in these licenses means. And, there's different ones, and you can see in our report, we gave some examples of it. But publishers go as far as prohibiting the use of browsers with connected AI functionality. Nowadays, there's no browsers that do not use AI. And publishers are prohibiting the library users from using browsers with AI functionality. This is how far it goes. We saw different variations of this. For instance, in the next slide, you see one that's very simple, straightforward. You cannot conduct text and data mining, which is exactly what the EU law allows you to do. And when it comes to the choice of law, I think typically what we are seeing is that they are choosing US law, maybe because the US law right now, it's not very clear if it allows these sort of uses or not. If it's a UK publisher, they will select the UK law, which also doesn't permit as many text and data mine uses as the EU law. So this is the first, the first category of obstacles and really damaging for research and science obstacles that we have noticed in our licenses. Then we also realized that suddenly these prohibitions were being paired with new standards for liability. So up until now, every license to the library sector required libraries to implement certain measures to ensure that there was no license infringement. And these kind of measures would be, ensure that the user is authenticated or ensure that the user knows the terms of the licenses. And provided that the library did this, the library would never be liable for any license infringement. That was the responsibility of the library user, the patron that is using the material. And suddenly, since last year, all the licensing offers that libraries in Europe are receiving have these new standards of liability that simply say that library is fully liable for the actions of the users. This mostly connected with the prohibitions of AI. So if the user does text and data mining, wants to use an AI automated application, etc., the library is automatically liable for that. And that, of course, was, I think, the no-go for most libraries in Europe. They are really scared about these new liability standards. And so much so that some are saying, after 1 year, unable to reach an agreement in terms of liability, they are simply saying, we are not moving forward with the license. And with big publishers that are really important for the scientific sector. And we have an example from a Finnish consortium. They were negotiating for 1 year with the American Chemical Society, which is a very important publisher in the sector. They've been having, for 25 years, licenses with this publisher, and they said, and they publicized this. So due to fundamental differences of views on liability issues, we are no longer signing an agreement with this publisher. And on top of that, you have strong penalties for non-compliance. And I can give you an example of that. So this full liability clauses as simple as this. So the consortium member, because normally, and I should give you that context, in Europe, we have these consortiums of libraries that negotiate licenses on behalf of the individual libraries. So when you see here, the consortium member is the library, so the licensee, may be held liable for non-compliance by authorized and walk-in users. This is insane. insane. It's impossible for a library to work with this framework. And then with penalties. So if you infringe, and we decide this at our sole discretion if you have infringed or not, immediate termination of the agreement without any refunding, denial of existing or any future access, civil, criminal penalties. I mean, any librarian that looks at this, they will just be so scared of doing anything, of allowing anyone to access the materials, that this is impossible. And that tells us a lot about what the framework needs to do in terms of rebalancing the power in negotiations of licenses. Then finally, one last category before I move into what are the solutions. One last category of practices, and I think this one has been well documented. We know that libraries, many publishers, not many, but some and important ones, refuse to deal with licenses, with libraries, so they refuse to license digital materials to libraries. Others do not refuse, but the licensing models are extremely disadvantaged to libraries. From bundling licensing, I guess it's one of those more perversive licensing models that are really disadvantaged to libraries because they don't get to choose which titles do they license. They are only offered this package of titles. They don't know which titles are in the bundle. And even if they only need 2 or 3 of those titles, that's the only thing on offer. You either buy this or you don't buy anything because we don't license one by one of the titles. And then worse than that, they withdraw whenever they want the titles from the bundle. So for instance, if the book that's in the bundle won a prize, or if it was selected for the course, they will immediately go and take out the title from the bundle, and it's insane. So what do we need to do to solve this solution? And of course, I think these are objectives and principles that can serve the WIPO work. But this is really important to think also at the EU level, I guess any level, regional level, national level, local level. So I will not talk about each of those objectives and principles because I know there are other speakers that are focusing on that. But first of all, of course, we need to ensure that contracts do not prevent the enjoyment of exceptions. That's what we normally call prohibition of contractual overrides, and Jonathan Ban will talk more about that later. Then we need to ensure that those choice of law provisions do not affect the enjoyment of the exceptions again. So it's another way of preventing contracts from limiting the scope of protection of the exceptions. And in this case, I guess what a simple way of saying this is that exceptions should be applicable irrespective of the law, otherwise applicable to the license. So there's many ways of doing this. You can treat exceptions as, overriding what we in Europe called overriding mandatory provisions. You could, for instance, create a new category of vulnerable parties. So treat libraries as consumers, and I know that Stephen Weiber will talk about this in this panel. So you could give member states the option to find the right private international law mechanisms, more or less intrusive, but do ensure that the choice of law will not limit the exceptions. Then, of course, if libraries are now being subject to these licenses that require them to be fully liable, I think we need a legal intervention as well to limit the legal exposure of knowledge institutions to liability. And I know our colleague Casper in the afternoon will talk about that. Then, of course, you might need to think about an obligation to license where the publisher already markets those works. Then he should not be able to refuse to license. And I know my colleague Justin will talk about that in the afternoon. Finally, even if you do not require publishers to license to institutions, you certainly can do something else, or in parallel or in alternative, you can require publishers, if they do license to libraries, they must offer conditions that are fair and reasonable. And you can say that these conditions must be adequate to the needs and specificities of institutions. So it would be an elegant way without saying that they need to offer fair and reasonable terms. And you can do much more, but I think this would be kind of the bare minimum from our perspective, coming from these practices that I just mentioned that are happening right now and are really damaging to the library sector, and I imagine for other sectors as well, and very important for education that depend on libraries, very important for research that depend on libraries, and the licenses that they have to access those materials. Thank you.